So we can, the AV's ready? Great. Okay, good morning, everyone. We're going to get started. My name is Elizabeth McIsaac, and I'm the chair of the Housing Rights Advisory Committee. The clerk has confirmed that we have quorum. We have a number of members joining us online this morning. So I'd like to call meeting 3 of the Housing Rights Advisory Committee to order and welcome everyone, and welcome to you online. This meeting is being held with committee members and staff participating both by video conference and in person at City Hall in Committee Room 2. Members of the public may also attend in person or observe the meeting on YouTube. I ask everyone for their patience today with any delays or technical issues. A few reminders. Staff, please keep your video turned off unless you are speaking or answering questions. Members and staff, please keep your microphones muted unless you need to answer a question or speak. And members, if you wish to speak, raise your hand or unmute your mic and let me know, and I will call on you. I also remind members that if you have any motions on any of the agenda items, they must be submitted in writing and can be emailed to the committee secretary at hrac@toronto.ca. And so with that to the side, I would like to begin a land acknowledgement. Although we are in different locations, in that we are gathering virtually, the committee would like to acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. I would also acknowledge that September 30th, which is next Monday, is National Truth and Reconciliation Day. And as we think about the work of this committee in particular, I think that as we look at housing rights in the City of Toronto, we have to think about that in the context of colonialism, of dispossession, and our work as part of the work of reconciliation. So as we begin to look at the items that we are examining and thinking about, I think it's an important reminder to center the experience of Indigenous peoples in that process. So, looking out, I would ask, can we please have a motion to confirm the minutes of our meeting from May 13th, 2024? Committee members received all of this, so if you've had a chance to review, thank you, Danielle. Moved by Danielle. All those in favor, and now I'm looking to the screen and around the room for hands going up. All in favor, B, that's a hand up, and carried. Thank you. So the first item for today's meeting is an update from me. You received a letter in the materials for today with recommendations. I will give a brief presentation from the Housing Rights Advisory Committee Priorities Framework and the activities of the working groups that convened over July and August. So as all of you are aware, because you all participated in one of these 3 meetings, we decided and moved at the last meeting that we would convene working groups to review the priorities framework and to discuss how we would get the work of the committee done. Over the course of July and August, 3 separate working groups were convened. We had to do this in smaller portions because we are unable to meet with more than 5 committee members without that constituting quorum. So we had 3 identical working group meetings discussing the same issues. And I'm pleased to say that there was consensus in each of the working groups that we arrived at the same place, which is a good sign. In the first instance, we discussed, clarified, and went through the priorities framework for the committee. In one of the working group meetings, there were some amendments suggested. They have been added into the priorities framework. The edits have been added in as a final document. The edits primarily were focused on including a gender-based lens, so emphasizing the importance of a gender-based analysis and also an intersectional analysis. And so those were minor edits that were added in. The finalized document has been included in your package for today. As part of those working group meetings, we also discussed how we wanted to get the work done. And so with some back and forth and the sort of discussion built over the course of the 3 meetings, there was consensus that we begin with 4 working groups, and that these working groups would mirror the pillars of the priorities framework, so that there would be one working group that focused on unhoused, there would be one working group that focuses on access to housing, a third working group that would be focused on maintaining housing, and a 4th working group that would be focused on supply. And so the intention and what we discussed in those working groups was that those groups would meet in between committee meetings, would be able to set a proactive agenda of what human rights, housing rights issues they would like to work on to advance over the course of this committee. Those working groups would also be available to do a deep dive on issues that the city has referred to us, so that if we are unable to discuss them in depth at a committee meeting, they could be referred to the working group for a deeper discussion with city staff and or set of recommendations made. So that's how we agreed that we would continue. The working groups will be convened between now and our next committee meeting. In September, we asked all of you what working group you wanted to be on, and so people have raised their hands, and you know what working groups you volunteered for. And so we will be getting in touch to set up the first working group meetings in the course of the next couple of weeks, so that they are able to be convened before November. And at those working group meetings, a few things will happen. We will identify a chair for the working group. I will not be the chair of all the working groups. I will stand in as chair to get them going, and then someone else will take over the leadership of that. We will establish a terms of reference for those working groups and set key objectives for each working group. And so that's where we netted out. And then the third issue that emerged from the working group meetings was an acknowledgement that in terms of the greatest need in our city, the issue of encampments continues to be an issue, a housing crisis within our city. Given the fact that there has already been a report from the Ombuds and actions have been taken by the city, this is a good sign. Given the fact that at the federal level, the Federal Housing Advocate has also issued a report on encampments and has prompted action on the part of the federal government to move significant resources to cities. That is something that is in process. We agreed that it would be of value to this committee to invite the Federal Housing Advocate to come to one of our meetings. I have informally checked with the Federal Housing Advocate, and she would be available to join us on February 6th. So that's the third recommendation coming out of our working group meeting. So with those 3 recommendations, I will pause there in case there are any comments or questions on that report. Okay. Seeing none, I think then we move to adopt the item as it's adopted. It's done, or we have to have a vote? We're going to have a vote. So all in favor, if I could see a show of hands. And Marie, are you good? Great, and Nicole, thank you. Okay, so carried. Thank you, everyone, and I want to thank the committee members in particular for making time over the course of the summer to ensure that those meetings did happen. Before we go on to the next item, I also want to express thanks and appreciation to one of our committee members. Dr. Daniel Raza has been on our committee from the beginning. We've only had 3 meetings, but Dr. Raza is in high demand in our city, and so he has recently been promoted to take on a much larger set of responsibilities in the delivery of health care to those in greatest need in our city, and as a result will not have the ability to continue in his role on this committee But I truly appreciate that someone who was as busy as he was and in the thick of what is so urgent to what our work is, put his name forward and has served us since January. So I want to thank Dr. Daniel Raza for his service and for coming out today for his last meeting. Thank you, Daniel. The next item is also sort of a business item. It is confirming our meeting schedule into 2025. So thank you to the clerks, the city clerk's office, who have gotten us in order. The dates are listed on your agenda. I would ask first, are there any questions on that item? Seeing no questions, are there any speakers to this item? And there are no speakers. So I would move to adopt the item. Can I see a show of hands, please, for all in favor? Excellent, excellent. Thank you. Motion carried. So the next item is a report from the Ombuds Office, the Ombudsman Toronto Housing Unit Status Update and Housing Rights Framework. This is a presentation from Luke Brown, who is the Acting Deputy Ombudsman for Housing, on the Housing Unit's Activity Status Update. This will be followed by a presentation on the unit's Housing Rights Framework. I'm happy to welcome Luke. Oh, Luke is already sitting in the chair, and I believe that we have the Ombudsman, Kwame Addo, also online to join in this, and so over to both of you.
Good morning, Madam Chair. I'd just like to say a few words before I turn over the meeting to Luke. I'm sorry that I'm not able to be with you in person today, excuse me, but happy that I'm able to connect with you virtually. So as you noted, I want to thank you for the opportunity to provide an update on the activities of Ombudsman's Toronto Housing Unit, which was established in July of 2023. In less than a year, we've made significant progress. We've hired a Deputy Ombudsman Housing and fully staffed the unit. We've launched 2 investigations. We've engaged with over 170 people through our outreach work, and we've developed a framework that Luke will discuss in greater detail later in his presentation that uses a concept of housing as a human right to guide our investigation work. So how did we get here? Well, in June 2022, Council asked my office to report back with recommendations on the resources and structure required for Ombudsman Toronto to focus on investigations and reports related to systemic housing discrimination and systemic obstacles related to the city's housing planning and services delivery rules, including the consideration of a deputy ombudsman. And so in early 2023, I responded to Council proposing the creation of a housing unit with my office, and City Council agreed. And in my report to Council, I made the point that my office has had a long history of addressing housing complaints in the city. We've also had we have the established infrastructure to build on. And finally, we have strong legal powers and protections that would allow us to do this work in an independent manner. And then in July of 2023, as I noted, we appointed a Deputy Ombudsman Housing. So the Toronto Public Service is responsible for several council-approved actions, such as the implementation of the Housing TL Plan, staff training and development for human rights related to housing, and monitoring progress through evidence-based metrics. The dedicated housing unit under a Deputy Ombudsman supports the successful implementation of these directives through various measures, both informally through advice and collaboration, and formally through investigations and review. The housing unit assesses the implementation of the city's housing plans through a housing as a human rights lens, focusing not only on the fairness of the city's actions, but also on the city's efforts to advance the progressive realization of the human right to adequate housing for all residents. I'll now ask my colleague, Acting Deputy Ombudsman Luke Brown, to speak in more detail about the activities of the unit to date.
Good morning, everybody. Can I get my presentation up on the screen? It's plugged in. Do I have to press something? There we go. Thank you so much. Okay, well, I won't go into much detail about an overview of our housing unit. I think Kwame's covered that quite well, including the history of the unit. So, again, we do systemic investigations and systems reviews and we can make recommendations to the city. So we don't have the power to order the city to take any action. We're not a court, we're not a tribunal, but we can make recommendations to push the city towards a fairer system and one that's more consistent with the right to housing. And then what we also do is we follow up with the city. After we make recommendations, we follow up with them on a regular basis until those recommendations are implemented. We advocate, but at a systems level, so we're not individual advocates. We don't advocate on behalf of a person or a group, but rather we look at systems and whether they are consistent with the right to housing and fairness, and if not, then we advocate for change. And we engage, we do quite a bit of engagement work with members of the public, other levels of government, housing organizations, advocates, really trying to make those connections to learn as much as we can about the most pressing issues involving housing precarity in our city. And finally, we offer advice, and we can act as a sounding board to city staff. So it's a very important role that we play. We sometimes call it proactive ombudship or preventative ombudship. But we work behind the scenes quite a bit, not through the formal investigations tool, but rather meeting with staff to offer suggestions on how they can improve their processes, improve their programs, and make them more consistent with the right to housing. So in just over a year at this point, we've got the first Deputy Ombudsman for Housing and fully staffed unit. So the permanent Deputy Ombudsman for Housing is Rima Patel, who's currently on parental leave and is expected to come back in the new year. We've hired human rights experts and folks with experience in the housing sector to work as investigators and policy work in our unit. We've got all of our infrastructure internally developed, and basically the housing unit now works quite well with the general side of our team, because we also do quite a bit of work. Obviously, the Ombudsman's Office traditionally has looked at administrative fairness. We take complaints from members of the public about city services, about programs. We investigate those. And now the housing unit has a particular role looking at the right to housing from a systemic perspective. So those two sides work together. And we provided consultations to city staff, as I mentioned. We've met with over 170 people as part of our outreach work. And we've developed, finally, we developed a framework, a housing rights framework that uses the principles behind the right to housing, as a tool to look at our investigative work. So it's very exciting. It's the first of its kind here in the city of Toronto. And it's the first of its kind in Canada, so we're very excited to use this tool and to present it to you here today. We're hoping that it can be used by other staff or other municipalities and other organizations that are keen on doing work that is consistent with the right to housing. Sorry, give me 1 second. I'm just going to pause the notices on my system here. Do you know how to close this? Okay, my apologies. So what's next? Well, we're going to continue to listen and learn from those most affected by housing precarity and homelessness to make sure that they're centered in our work and in the city's work, and to help us identify as well our future systemic investigations and reviews, as well as I mentioned, our consultation work and our behind-the-scenes work that we do. So, and all of that information, there's more detail as well. If you're interested, we have the status report, which is available online, and that kind of goes into a little bit more detail about some of the things that we've done. I mean, I can give you a few just examples off the top of my head. We did investigation into the city's response to encampments. And that was done by our general side, but now the housing unit is following up on the recommendation implementation. So we helped consult with staff as they were developing their interdepartmental protocol for their encampment response, and we gave them some advice on that to help strengthen it, make it as strong and as consistent with the right to housing as possible. And that was adopted this past summer. We, do kind of smaller, kind of one-off consultations. We've helped 311 ensure that their staff are directed to provide resources, to information basically to callers to 311 who are looking for help if they're facing eviction. We've provided some advice on the city's tenant, the eviction prevention handbook to try to focus tenant organizing a bit more prominently. So we do lots of work like that that's kind of behind the scenes in addition and complementary to our systemic work. Now, when it comes to our formal investigative work, that's where really the housing rights framework comes into play. And I was interested to read through your priorities framework, and I think there's quite a bit of overlap, obviously, and they're very complementary. So I'll just go through this very, very quickly. Again, this is available online as well if you'd like to look at it in more detail afterwards. But I won't get into the details behind the human right to adequate housing. I think we're all generally familiar with the ideas behind it. What we've done is we've taken the Toronto Housing Charter, which is based on those principles, and we've kind of distilled it down into a framework that we can then use when we're looking at whether the city has acted in a way that we think is compliant or consistent with the right to housing. So. Basically what we do is we go through a three-stage analysis. The first one we ask is, has the right to housing, to adequate housing, been engaged through one of three pieces? The first is adequacy, the second is non-discrimination, and the third is participation and inclusion. Now the next is, were the city's actions consistent with its obligations and in line with 7 principles that we set out in the framework? And then finally, we make recommendations to help the city move more closely to progressively realizing the right to adequate housing. So I'll break those down in a little bit more detail. So stage 1, we look at 3 pieces, as I said: adequacy, including whether they meet specific criteria around tenure, habitability, affordability, and so forth. Non-discrimination, the Housing Charter talks about equal treatment and protection from discrimination based on grounds under the Human Rights Code, and protects residents from discrimination based on homelessness or housing status. And then finally, participation and inclusion. So here the principle being that residents must be involved in decisions that affect their housing rights. Now at our stage 2, we look at the guiding principles for cities' decisions and actions. So stage 1, we look at whether folks have been impacted. Stage 2, we look at what has the city done to try to progressively realize the right to housing. Have they centered human rights impacts in their decision making? Is that their primary consideration? Has the city used all appropriate means to try to advance the right to housing? Have they used maximum available resources? Have they prioritized? Have they focused on the people who are most in need, most in housing precarity? Have they meaningfully engaged? Have they collaborated with other governments? And finally, we look at environmental sustainability and resilience. And we won't necessarily look at all of those in every single investigation. We will generally pick the ones that are most relevant to the investigation at hand. And then finally, as I said, we'll make recommendations. Again, don't make orders, we make recommendations. But we want them to be ambitious and achievable. They have to be people first, and they have to put the principles of the Housing Charter front and center. We make those recommendations. We generally have a back and forth with city staff after we make these recommendations, before we finalize them, to make sure that they are practical and that they'll make a difference. And after the city adopts them, then we make a plan to follow up with the city. Typically takes the form of quarterly meetings. We'll meet with staff. They'll send us draft policies or procedures that they're developing in response to our recommendations. And we can weigh in on those to make suggestions to strengthen them. And we follow those until they're finally implemented. So that is, in a nutshell, what our housing rights framework looks like. Again, I'm happy to take questions, and I'd encourage you, if you get a chance, to take a look at it in a bit more detail. And we welcome your feedback. It's obviously going to be a living document that we'll refine as we go forward. But that's it in principle, and it's a tool so that we can be transparent with the city and with the public about how we're looking at these issues. And again, happy to take any questions if anybody has any about the framework or about our status report. Thank you so much.
Thank you, Luke, and thank you, Kwame, as well, for joining us today and for sharing this. I think this is really helpful and important to this committee. as we begin to build our own framework for assessing the human rights realization through housing at the city. And so I think the framework you've developed is a really important thing for us to look at in terms of how that resonates with what we've been thinking so far. And I also think it's important that we continue to work very closely, because if you look at the structure of the city's commitment to realizing the right to housing, these are sort of the two cornerstones of mechanisms for working on this. And so the more that we're able to work together, I think the more effective we can be around accountability. At this point, I'd like to open it to the committee. If there are any comments or questions that you have for Luke or for Kwame, this is the time. So I will pause and see if there are questions. Saroja?
Hello. Yeah, thanks for the presentation. I'm just curious about other housing rights frameworks that maybe were designed for other levels of government within Canada, and how this one differs from those, or what you think is unique about this one.
Through the chair, thank you. That's a good question. So I mentioned from an ombuds perspective, this is the first for an ombudsman office, which is really our obviously that's our work as an ombudsman office has to be tailored to the kind of work that we do. I'm not familiar with, like, we certainly, when developing this, we took inspiration from some of the analysis done by other housing rights organizations, other advocates. I can't think off the top of my head of a similar tool like this at another level of government, and I might be mistaken, but really it is fresh and it's tailored for our office. But I think the principles in it will be generally applicable, that it could still be useful for other organizations doing this kind of work. But in direct answer to your question, I'm not familiar. Not to say that there aren't any out there, but I'm not familiar with anything else that is particularly on point.
Joy?
Yes, I just have a question of clarification. When you talk about the recommendations, who are you making the recommendations to? In other words, what's the path from your office to change?
So typically what we do is we make recommendations to the city division that is most involved in the investigation. So normally what we do is we'll in a formal investigation, we'll issue notice to the city manager, but we'll specify which division, because there are so many at the city, but which one is really most directly involved in delivering the program or the service that we're investigating, that we're looking into. And so then generally the recommendations would be agreed upon by that division. So then it's usually the leadership of that division that we meet with, typically, as I said, on a quarterly basis, and any other staff who might be involved as well in helping to develop the tools or the procedures or whatever else we've recommended that they do. So generally we have quarterly meetings with the leadership of whatever division is most directly involved.
Thank you. That's helpful.
Bahar?
Thanks so much for your presentation and the work of the Ombudsman and the Housing Unit. Can you speak a little bit, two questions for you. One in terms of how do you assess meaningful consultation and engagement? And just the other question, has the unit and the Ombudsman's office in general looked at how you would collaborate with other levels of government bodies, like currently the Federal Housing Advocate Office and role?
So those are both very good questions. Maybe I'll start with the easier one first, the second. Collaboration is, we're still developing our strategy or our plan for how to work with other levels of government. We certainly do communicate with other organizations such as the Federal Housing Advocate. You know, we're always interested to see if there are ways to either make sure our work is in line with theirs or complementary. So that piece is still a work in progress. The idea of kind of systemic advocacy, intergovernmental advocacy, is not something an ombuds office generally gets involved in. So we're trying to find a way that's consistent with our mandate, but still helpful working, given that the housing crisis, the adequate housing crisis is not going to be solved by the city alone. We certainly do need to think about the role of other levels of government. So that's still a work in progress. Now, in terms of adequate consultation, that's also a great question, and it's so context specific. So the other thing is we're not the ones who are designing the plans for consultation. And so what our goal is to try to ensure that city are coming up with their consultation plans in a way that's thoughtful and responsive to the needs of the people most impacted. And so working with city staff to come up with plans for that, and whether that means that they hire outside consultants to help lead, for instance, a consultation plan, which has happened in a couple of cases, or whether they're developing internal staff capacity to try to do some of that consultative work. It really depends on the situation. But again, it really depends on which file we're talking about, but that's the general principle. Is like we're not going to design the consultation itself. We're going to work with the city to ensure that they're coming up with processes that are responsive, that are going to make sure they're listening to the people most directly impacted by a housing issue, the most precariously housed, and that their consultation is done in a way that's in line with the values in the housing charter.
I'm looking at the committee online as well to see if there's any further questions or comments. Are there any speakers to this issue? Looking at the clerk's office, there's no speakers to this? Okay, thank you. I'd like to, sorry, 3.5, okay. I would like to say thank you, both to Kwame and to Luke, who have been reaching out to sort of coordinate and think out loud together about how we move this work forward. This is new work, and I appreciate that the Ombudsman Toronto is a pioneer in building out a framework for social and economic rights. This hasn't, to my knowledge, been done elsewhere. And so I appreciate the work that has gone into doing this and figuring out how to, as you said, Luke, do this proactively with city staff so that it builds a new way of working with city staff that is not just reactive, but rather works hand in hand to figure out how we progressively realize the right to housing. My question to you would be, is there anything that we can be doing as a committee that would be helpful to you in a sort of more formalized way? At this point, it's been more conversational back and forth, but is there a formalized way, given that we have committee meetings, working groups, that would be helpful to you as an office in setting your priorities or moving your work forward?
Thank you for the question. Yes, I think having a formalized relationship would be helpful, and I think it would be something that we should discuss setting out in writing. I know we've had these conversations before, but having a sort of a framework or perhaps even something like a memorandum of understanding between our two organizations that can really lay out how we will work together. And I'm excited to see the creation of your 4 subcommittees, because I think that will be an opportunity for us to come, with your permission, of course, to come and speak or become involved with those subcommittees to be able to exchange ideas. And so if we're spotting issues that might not be appropriate or that we're not able to engage with, perhaps referring them to you for you to look at, or vice versa, and using you as a sounding board as well. Because there certainly will be overlap. We don't want to duplicate our efforts, and so I think having a formal structure set out that describes exactly how we're going to communicate those ideas back and forth, by what mechanism, and then what we hope to accomplish from that would be very helpful. So perhaps that's something we can discuss further as we move forward.
Thank you. I think that would be helpful because we don't have the capacity or competencies to do systemic investigations or systems reviews. I think the overlap is about engaging people with lived experience and bringing that into our thinking and having that sort of ability to hear from communities of rights holders. And so I think the more we're able to build a bit of a working relationship, the better we can both deliver on our outcomes. Not seeing any other questions then, I will say thank you very much for joining us. Oh, sorry, one more question. Is there, you mentioned an investigation in the report on refugee access to shelters. Are you able to tell us when we can expect that report? Because I think that would be of interest to this committee.
So that we are finalizing, so as soon as practical. I can't give you a precise timeline. We're hoping before the end of the year.
Okay, terrific. Thank you very much. Okay. 3.5. So that, I think we need a motion here to receive the information. So can I will move to receive this item for information with thanks to the Ombudsman's office. All in favor, can I see your hands? Thank you. Online, I'm looking. Thank you. Thank you. Yes, Bahar.
I love that idea of formalizing a relationship. How do we go about doing that? Can we pass a motion on this item to explore how we can perhaps sign an MOU or?
It's a good question, and I'm looking at my colleagues from the clerk's office for advice on how to capture that. It contains in that, or do we need to add to it? Okay. Okay. A motion. So I can draft a motion and we'll come back to it later in the meeting? Is that what we should do? So we'll hold the item? Okay. So that's what we'll do. So we will reopen the motion, the item. We will reopen the item later in the meeting. We'll reopen it right now.
Yeah, they want to take a vote.
And let's take a vote. And we are voting on the committee. We're reopening the item, so we need a motion to reopen. Can I please see a show of hands to reopen the item? Thank you. I can't see my online colleagues. Are they voting yes? Everyone has their hands up, so the item is now reopened. And now we're going to hold the item until later in the meeting, and we will come back to it. Thank you. And thank you for everyone's patience. I am still new at the work of the committee. So we will come back to that. Thank you. The next item is an overview and discussion of Toronto's proposed Renovictions bylaw by the Toronto Housing Secretariat. Members, this is a presentation from Matt Hilder, the Acting Director, Housing Secretariat, Aisha Salim, Manager, Policy Program Planning, Housing Secretariat, and senior city staff outlining a proposed bylaw aimed at preventing renovictions in the city. Over to you.
Thank you, Chair. You can hear me okay? Okay, so introductions, as the Chair said, Matt Hilder, Acting Director of the Policy and Strategy section in the Housing Secretariat. I'm joined by Aisha Salim, our Acting Manager of the Renter Strategy team, and Ted Van Vliet, who's a Project Director with Toronto Building. And we're happy to be here today to present to you on work city staff have been undertaking on implementing a renovictions bylaw for the City of Toronto. So briefly, what we'll go through is just provide a bit of background on Council's direction around renovictions, and sort of the need and the urgency for a renovictions bylaw in the city. And then we're really here to talk and present to you some of our approaches around the implementation of this bylaw, an overview of the consultations we've undertaken, and then talk about next steps. I think off the top, it's important to note that staff have been directed by Council to move forward very quickly with coming up with the renovictions bylaw. So we are reporting back to the October 30th meeting of the Planning and Housing Committee with a draft bylaw for committee and then Council's consideration. So first and foremost, what is a renoviction? I think the members of this committee will be very familiar with the term. The city defines a renoviction as an illegitimate eviction by a landlord claiming the need for vacant possession for the purpose of renovations. Renovictions can include things like refusing a tenant to return post-renovation, illegally raising the rent on a new or returning tenant, or not undertaking major renovations at all after the eviction occurs. We note there's a growing trend of renovictions in Toronto, and that renovictions generally result in the displacement of tenants, often the loss of what was previously naturally occurring affordable rental housing in the private market, and can also lead to rising homelessness in the city. In a housing context like Toronto's, where we have very low vacancy rates, rapidly rising rents, and a housing and homelessness crisis, addressing renovictions is of utmost importance to us. So in terms of council direction, the story actually begins before June of this year. So City Council and various committees of council have been directing staff to look into renoviction since about 2020 or 2021. In 2022, city staff brought forward a policy framework for developing a renovictions bylaw, which really kickstarted a lot of the formal staff work around developing the bylaw that is in front of you or will be presented to this committee today. An important sort of step in this process was in January of 2024, the City of Hamilton in Ontario adopted its own renoviction bylaw, renovation license and tenant relocation bylaw. And that really became a model for the City of Toronto. And it was in June of this year that we were directed by City Council to come up with an approach to implement a Hamilton-style bylaw here in the City of Toronto. So at that June meeting, in addition to reporting back in October of this year with that draft bylaw, we were also directed to conduct engagement and consultations on a Hamilton-style bylaw for the City of Toronto, and include the results of that engagement in our report back to the Planning and Housing Committee. Obviously, an important milestone for us is to come and speak to this newly formed committee and receive your input and advice on a renovictions bylaw, and so that brings us here today. And now I will pass it over to my colleague Ted in Toronto Building.
Thank you very much. Good morning, committee, and through you, Madam Chair. The direction from City Council identified several aspects that they wanted staff to incorporate into the bylaw and figure out how to make work within the bylaw. The first requirement will be that upon issuance of an N13 to a tenant, that a landlord would be required to apply for a renovation license within 7 days of providing that notice. So they would issue it to the tenant. Within 7 days, an application to the city would be required to be made. There would be a fee associated with the application. We would need copies of the N13 notices so that the city had all of the details. We would also need copies of any approved building permits associated with the renovation to take a look and make sure that the renovation being proposed was in fact substantial enough to require vacant tenancy. There would be a requirement for a third-party report from a qualified person, and trying to determine who and what a qualified person is and what sort of information that they would be providing the city was part of the matter that we've been consulting on, and certainly something that we would like to hear your advice on as well. There would be a requirement to submit a tenant accommodation and compensation plan. What happens to the tenant during the renovation? And how are they looked after? How are their needs looked after? And then any other information requested by the city in addition to those things. And that again would be something that we would be interested, that we've been consulting on, and that we would be interested in hearing this committee's advice on. So under the Residential Tenancies Act, the landlord can serve the N13 eviction notice. There is no application process or anything like that. It is between the landlord and the tenant. The city cannot interfere with that relationship. We can't prevent N13 notices from being issued, nor can we stop that process once it is underway. So the rental renovation license is seen as a complementary process or a parallel process to the processes within the Residential Tenancies Act. So we have to be very mindful as we go through this that we stay within the city's jurisdiction as to what we can and can't control, and also to manage the expectations of those tenants, of those landlords, that the city cannot intervene in any landlord and tenant disputes. Next slide, please. So the qualified persons report, this would be a third-party independent verification to take a look at the work that any building permits had been issued for, that was underway, and to provide an expert opinion that yes, vacant tenancy will be required in order to carry out this renovation, that there really are no other options available, that type of information. Who that qualified person is and the type of information that we would be looking for is something that we have been consulting on. There have been conversations with a number of professional organizations as well as members of the public, tenant and landlord groups as well, as to who that qualified person may be. So, next slide, please. The tenant notification requirement. So once a license is applied for, the city would require the landlord to provide forms of notification to the tenant that a license had been applied for. There would be a requirement to post a tenant information notice on the property so that the tenants would be aware that this application has been made. We have an example of it on the next slide, but the idea behind this tenant notification requirement would be to make sure, first of all, that the tenant was aware that the license had been applied for, but also to provide resources that the tenant could access should they need support or advice as they're going through this process, so that they can find out exactly what their rights are. The city would also explore some sort of public registry, an online registry. We have similar tools for tracking building permits and construction processes, so that the tenant, interested parties could from afar monitor the process of the renovation and any building permits associated with it. Next slide, please. And this is just an example of what a tenant information notice could be. Again, having some basic information about the renovation, about the contacts, and then resources that the tenant could access to get more information, to find out about their rights, to find out about the licensing process through that. And I apologize, it's not an ideal one, and certainly what we should be informing the tenant, that is another thing that we're interested in getting advice on. So any thoughts would be welcome. Thank you.
Similarly to the Hamilton bylaw, this new bylaw would include a requirement for landlords to submit a tenant accommodation or compensation plan that's signed by the tenant and that both parties have agreed to. The plan would require landlords to either provide temporary alternate accommodation that's equivalent to the current unit's rent, or to pay the tenants the difference between their rent and the average market rent for a unit that has the same number of bedrooms. We've gotten feedback via the consultations that the city should consider enhancing these standards to align with what is currently in the city's rental replacement bylaw, and we're taking that into consideration. In addition to these requirements, landlords would need to keep records showing compliance. And then under certain circumstances where landlords have fulfilled the requirements of the bylaw, they may be granted exemptions if they apply for one. A landlord would be required to show proof that they've endeavored to reach an agreement with the tenant. In order to best support tenants to exercise their rights under the RTA and a future bylaw, we know that they're going to need access to legal advice as well as information on their rights. The city funds a number of organizations to deliver legal services and tenant rights information, including the Canadian Centre for Housing Rights, the Federation of Metro Tenants Association, and the Centre for Immigrant and Community Services. These services will be part of the implementation of the bylaw, and will be working collaboratively with the TO tenant support partners on how to best support tenants as the bylaw is launched. The city is also considering whether a phased approach should be implemented for multi-tenant housing to align with the implementation timelines of the new regulatory framework for multi-tenant housing. However, we understand that multi-tenant house renters are some of the city's most vulnerable tenants and may be at risk of renovictions, and we're aiming to balance the need to protect them under a renovictions bylaw with the need to ensure that operators also stay in the business of preserving this important source of affordable housing for tenants. We're also considering whether an exemption from the renovictions bylaw should be provided for community housing providers, given that there are existing policies and processes in place for tenant relocation in the TSH, in TCHC, and in the sector operated and owned by nonprofit housing organizations and providers. I'll speak a little bit about the consultation approach. Public Progress was retained by the city to conduct community consultations on the proposed renovictions bylaw. And the purpose of the consultation was to gain feedback from the general public, tenants, and property owners on the implementation of the bylaw, modeled on the City of Hamilton's renoviction bylaw, as was noted, and to also raise awareness of the proposed implementation of a Hamilton-style bylaw. The consultations were also designed to help apply a human rights-based approach to developing the bylaw. This included ensuring that tenants as right holders were engaged in the consultation and that decisions that will address their needs and affect the realization of their right to housing. Consulting on how the implementation impacted different groups, such as landlords and tenants, and also prioritizing understanding the needs of those who face greater barriers in the realization of their rights, namely tenants and tenant groups, with an understanding of the experience of tenants who have gone through renovictions. And moving to the next slide, I'll speak to the specifics of the consultation approach. The consultation included separate focus groups with tenants and tenants with lived experience, tenant organizations, and landlords. It encompassed 11 stakeholder meetings that included over 20 organizations. And then in order to also focus on consulting with rights holders, Public Progress collaborated with Acorn to organize a community-based focus group consultation with tenants. Public Progress also hosted 6 in-person open houses in Toronto West, Toronto East, North York, Etobicoke, Scarborough, and downtown Toronto, and 1 virtual public session. And then finally, a public survey was launched in August, running until September 30th. Responses are anonymous and will inform the development of the bylaw. And finally, what you see here in front of you is our next steps. We are going to Planning and Housing Committee on October 30th. If approved, we will be going to City Council on November 13th with a plan to launch the implementation of the bylaw over the next year. We're also noting that stakeholders, including tenants and landlords, will continue to be engaged on the implementation of the Renovictions bylaw leading up to the launch of the bylaw, including the Housing Rights Advisory Committee. Thank you.
And back over to you, Chair. That's our presentation.
Thank you very much. So I suspect there's going to be a number of questions from the committee, so let's open that up now. And I've got my screen on to see who would like to go first. Bahar, that's your hand.
Thanks so much for the presentation. I have lots of questions. I will ask a couple and then we'll wait for others if they have questions. Could you speak to the process of just the overall process and how it would work with property standards and rent safe TO in terms of buildings that are required to do X, Y, and Z, related to renovations within their building? Just kind of overall, like what has been kind of the thinking around that? Because what we've heard from tenants is, as an example, someone will keep their building in a state of disrepair until the renovation has to happen. And in addition to that, I think this is related. What is the purpose of the application fee for the renovations license?
I can start maybe on the MLS, and then I think I'll hand it to Ted probably. So not at this table, but a part of our team is Municipal Licensing and Standards, who run the Rent Safe TO program. And similarly on the multi-tenant housing framework, that's sort of an initiative led by them. And the intersections between this new bylaw and those bylaws is a key consideration for us. One thing I might, for example, point you to is in terms of issuing a license, something staff are looking at is whether a landlord would need to be in good standing under those other programs in order to be issued a renovation license under the Renovictions bylaw. That's just one example, but I think generally the Renovictions bylaw is in a different vein than the property standards bylaw, but we recognize there are points of overlap in terms of the role the city's looking to play in preserving rental tenancy, so they're certainly part of our consultations. I'll maybe pass it over to Ted if you want to add any more detail on the involvement of MLS or speak to the second question.
Thank you. I don't want to speak on behalf of MLS, only that we have had discussions about that there are multiple bylaws governing multiple things here. And generally the requirement is that where there is an active bylaw, you need to comply with all of them. And we're not looking at this point, necessarily changing that practice, although we are still gaming out a number of scenarios because we are aware of the overlap and the intersect between them. With respect to the purpose of the application fee, it would simply be tied to the cost of delivering the service.
Thank you. Are there other questions from members of the committee? Yes, Joy. Please. Go ahead.
I'm like Bahar. I think I have a few questions to ask, but I'll start with this. Matt, in your slide, you were saying, talked about the considerations of aligning with the implementation timelines of the new MTH framework. And I was curious, what are those considerations related to timeline? What are you thinking?
Through the chair, I can start and again turn to my colleagues who may want to add more. We're thinking about the implementation of the multi-tenant houses framework, as reported to council, was to go through a couple of phases. So the up until March of this year was sort of readying for implementation. Year one, from March of this year until next year, is focusing on supporting licensed multi-tenant homes to come into compliance with the framework. And then following that point, the focus of staff resources would move towards bringing unlicensed multi-tenant homes into the framework. So part of what staff are considering, again in consultation with MLS, is how the renoviction bylaw would or would not apply to MTH landlords in various stages of the licensing process, and how we consider, as I think Aisha and Ted both indicated, the intent of the MTH framework is to bring more landlords into a license and into compliance with the regulatory framework. So we're thinking about how the application of a Renovictions bylaw could or may not support those landlords with coming into that compliance. So we're really thinking about, and obviously every individual property and landlords goes through a different process depending on what they need to do to comply. But these are some of the timeline considerations we mean when we reference sort of the implementation of the multi-tenant houses framework. I don't know, Ted or Aisha, if there's anything you'd like to add.
Joy, did you have a follow-up to that?
Sure. I guess when I look at the Renovictions bylaw, what I see positively, is that this should be a pretty effective deterrent to prevent large, buildings, high rise, all the things that we read about, in the papers. I think could be very effective. I think the costs for the small landlord will be felt to be, prohibitive, to be able to relocate tenants and hire a, expert to view their property. Sorry, I'm having some lung troubles today. So I guess my sense is that the best case scenario for a small landlord is to do the renovations with tenants in situ. But the worst case is relying on the ignorance of tenants who haven't, don't know their rights, to simply evict them, without, going through any kind of process at all, or evict for own use rather than for renovations, or to sell the properties outright. And I guess I'm wondering, what are the steps that the city can take to avoid that eventuality of people just losing their housing?
Through the chair, great questions and very complex questions to answer. I think the first thing I'll say, and maybe I can pass to colleagues in Toronto Building to speak about how we're thinking about fee structure, is that the role of those TO tenant supports programs organizations that we fund and work with, the Federation of Metro Tenants Associations, Canadian Centre for Housing Rights, and Centre for Immigrant and Community Services, are really key vehicles for us to get information into the hands of tenants about their rights and create, in some cases, channels and phone lines where people can have conversations. So I think whether it's the multi-tenant houses framework or the Renovictions bylaw, that approach of using community-based organizations that have trust and relationships with tenants to get information into the hands of tenants about their rights is really the sort of critical step for us in terms of preventing other styles of eviction where tenants may be at risk of losing their housing. I don't know if Ted or Aisha want to add.
Thank you. I don't have too much to add to that. With respect to the fee structure, we did hear from landlords that adding an additional cost, of course, is not something that they're too keen on, and that we're certainly aware of. So we've looked at what the City of Hamilton has done, and they have a fee that is set up for that. That fee covers part of the cost, and then there's a portion of that recovery that is through property taxes, is my understanding. as well. So there is likely to be a mix. Instead of going for a full cost recovery model, that there may be opportunities for a mix. Those different combinations of fees versus taxes are being explored right now.
Through the chair, one other thing I meant to add, a key piece for us and through the Hamilton bylaw as well is that qualified persons report is really critical. Our understanding is that the vast majority of renovations to tenanted properties do not actually require vacant possession, that is a very, very high bar to meet. This is our understanding from jurisdictional research we've done in BC, which is a fair bit ahead of us here in Ontario in terms of how they address renovictions. And so for us, that is a key ingredient in this process. And our understanding is that the vast majority of renovations to a tenanted rental property do not require vacant possession and the moving of the tenant out of the unit. And so that's really a key focus for us in implementing this bylaw. And I think that speaks to some of what you were referencing, Joy, in terms of the pressures on tenants being relocated is really deterring the illegitimate renoviction of tenants in cases where that vacant possession isn't required.
Go ahead.
Maybe I should just check. Are there other people who have questions? Because I don't want to take too much time on.
Well, I saw Harmy had her hand up before. So, Harmy, do you want to go ahead or let Joy have her follow-up?
Oh, no, I'd like to, Joy to have her follow up.
Okay, and then over to Harmy. And B, did I see your hand up earlier? Yeah. Okay, and then we'll go to B after Harmy. So, Joy, back to you.
Yeah. Now, I had the impression from an earlier meeting, and I may have got it mixed up. Are they saying that it would cost somewhere $10,000 to $15,000 for a qualified expert?
I'll try to speak to that. I think 10,000. I'm not an expert on what engineers or architects or other qualified professionals actually charge. I have an idea. I don't think it would be that high. That seems like a very, very large fee for that type of work based on my experience. It's difficult to ballpark, but then again, it will depend on the complexity of the question and the complexity of the assessment and the work that qualified person needs to do. I would say that $10,000 sounds high, but again, that's based solely on my experience.
I'm thinking particularly of the small landlord, where that would just be a huge amount of money. It actually made me wonder, are building inspectors, the city's building inspectors, qualified persons?
Building inspectors do have qualifications under the Building Code and the Building Code Act that they are required to have as a part of their duty. Whether they would be considered or be appropriate, frankly, for it to be a qualified person under this bylaw, that is a question. The city will be enforcing this bylaw, so having city staff being those qualified person, it's most likely that would present a conflict of interest. But we have heard similar suggestions from people, but it's something that we would be aware of. So yes, they are qualified to do their jobs. To be a qualified person under this bylaw, it may not be the best because of those conflict concerns and issues.
I recognize that. I'm just trying to keep the costs down.
Sure, certainly, yes, I appreciate that. Thank you.
Landlord, I actually like a punitive approach because they are the ones, this is where you get the fraudulent, the posers doing these evictions. I guess the other final question I have is, what happens when the landlords, and I'm thinking of MTHs here, doesn't want to renovate, and the tenants actually probably feel ambivalent about the disruption, but the city requires it. In other words, a city inspector has come and said, you need to do all these renovations.
So
what is, okay, go ahead.
Yeah, sorry. So that is an issue that we've looked at. The Hamilton bylaw, I believe, and I would think that we would want to incorporate something similar, is that where a building inspector or a chief building official has made a determination that a building is unsafe and needs to be evacuated for the safety of the tenants or anybody involved, to make them go through a licensing process is probably not the best course of action, they need to be out of there quickly. I can tell you that those orders are very rare, but they do happen. And our hope would be that compliance with property standards requirements and other requirements and just simple property upkeep would avoid those circumstances, but sometimes things do happen that force those orders to be made.
Thank you.
Thank you.
Okay, Harmy, over to you.
Yes, thank you. My question is about the consultations and wondering if there could still be an opportunity, and please correct me if I'm wrong. I don't know if there has been a gender-based violence or violence against women agency, organization, or network engaged in the consultations. I'm not saying that there wasn't any in the groups that you consulted, but having that specific group could probably bring additional information that could be helpful for this bylaw. And if I know there is still, like, the public survey is still open, I wonder if there could be an additional attempt to reach out to those groups to gather additional information, or if there has already been that attempt. And so that is my first question, and not question, is question, I guess, and a comment. And I understand that stakeholders will continue to be engaged as you continue to implement. So then to highlight the importance of the groups of those who have experienced violence and who, in addition, may be evicted, to provide additional insights into it. So any thoughts or comments on that?
Through the chair, thank you, Harmy, for the question. We can take back in terms of the stakeholder consultation and focus groups we went to. I do believe for the distribution of the survey that went out to the broadest sense through all of our networks, and I know that that working group that my colleague leads was on that list, and so we would have spread the word that way. And as you point out, there are a lot of important components of this bylaw over the course of implementation, where there'll be other opportunities in greater detail to dive into specific elements. But we can take that back and reach out through to you directly or through the committee process or whatever to give you a summary of that.
Right, thank you.
Thank you. B, you had a question?
Yeah.
And then Sarosha?
I don't know. I once had this experience. I don't know whether it's under this renovation category. I once ran a place in the basement, and then I think it's more than a year. And after that, the landlord told me that I need to move. The reason they give me is not because they want to renovate the place or whatever. The reason they give me is they need the place back. So that was my very first, that, landlord asked me to move. So I was very confused, and also I was like for a person like me on social assistance, it's very hard to find a place. So I really reluctant to move because I'm a good tenant. I pay my rent on time, and I'm a quiet person. I don't like party. I never, have friends come, overnight or whatever. So I was like, there must be reason to me that they want the place to take back the place. To me is an excuse. Right, so I that time I didn't even know this community legal clinic, but I think somehow I saw a pamphlet about this community legal clinic, so I called them, and I said my situation is is that true that they really want to take back the place for their own use? And the legal clinic person told me maybe not. Maybe they want you to move, so when they want to rent it out to another person, then they can increase the rent. Yeah. So would my situation, would that under the renovation?
Through the chair, thank you for the question. It sounds like that would be an attempted eviction for own use, which I think is under a different, there's different names given to different eviction notices. Renovictions generally fall under an N13. That sounds like I think an N12. And so that doesn't sound like the type of scenario that this bylaw would be looking to prevent, because based on what you've told me, the landlord wasn't looking to renovate and using that as the excuse. But what you have said is really highlighted the importance. You mentioned a pamphlet and having a community legal services to call really highlights how important it is that those organizations are well resourced and out in community, and tenants have information about how to access them so that they can call for help in those other situations. Like the one you mentioned. So really an excellent point, and really highlighting the importance of information and resources for tenants about their rights.
So in that case, can I not move? Right, because there's no reason, right? I pay my rent on time, I'm a good tenant.
I would say in that case, I would defer to the legal advice you're getting, or you would have gotten from the legal clinic. I can't speak to that particular scenario, and it doesn't sound like a renoviction, but I think in those cases, it's really important for tenants to have access to legal clinics and other associations that can help them determine the best next steps to take.
Thank you.
Thank you. Saroja, did you have your hand up?
Yeah, I have asked this before, but I feel like I need to ask it again, just in case there are any pieces of progress made on it. I'm just curious about renovictions that are done informally. So what happens when a landlord doesn't use an N13 and a tenant makes a complaint about it to a legal clinic or a landlord-tenant board or another association? Like, what are the repercussions there, and how is the city monitoring landlords who aren't compliant with the renovictions bylaw? So I guess this is two questions. The second one is for those who do apply to the N13, and then the city determines that this is not a legitimate, application. This does not, in this scenario, tenants wouldn't need to vacate. Like, what happens in that case?
I'll try, and then my colleagues can jump in and supplement whatever I can say. For a landlord that chooses not to properly use the N13 process, that would be a provincial matter. They would be in violation of provincial law in that case, and so it would be incumbent on the province to address that. Should they go through that process, it triggers the need for a renovation license with the City of Toronto. And once they're in that process, should they fail to make an application within the 7 days or whichever time period we land on, they would be in violation of the city bylaw. And we would have enforcement mechanisms available to us under that, whether it's tickets, whether it's a summons to court, whether it's an order to comply. There would be a series of enforcement mechanisms that we would have available. And then once they were in the licensing process, in the city's licensing process, and if something went out of step, if something wasn't complied with, we would have, again, enforcement mechanisms available under the city bylaw to take action. The first enforcement mechanism, and the preferred one, is always education. Of course, we can't emphasize that enough, both for the tenant and the landlord through this process. However, if something does go sideways, then there are punitive or corrective measures that would be available. I hope that answers your question.
It does answer my question. Yeah, I think I'm concerned about the provincial piece as well. So thank you for shedding light on that.
I think I saw Gord's hand, but Bahar, you were up first. So no Gord, just Bahar.
Kind of similar to the question that you just asked, and to B's concerns as well. The goal of this bylaw is to limit the number of no-fault evictions that are in bad faith, correct? So I understand that staff were provided direction to look at the Hamilton Renovation bylaw as an example. It is very narrowly focused to N13s, and it doesn't obviously include many other illegitimate ways that landlords try to have a vacant unit. So has the city looked at other jurisdictions, for instance, in BC, where the definition of a renoviction is more broadly seen, so that it's not at the moment of an N13 eviction notice that that this bylaw would be kind of implemented. And for me, one of the concerns is that when you have a bylaw for something very narrowly focused on N13s, then a landlord that may want to act in bad faith now will go other routes to try to renovate tenants. In B's case, maybe someone will use a landlord's own use situation. So can you just speak to how staff has looked at that, and is there an opportunity to expand kind of that definition to include other instances where it's not an N13 involved case?
Through the chair, thanks for the question. And I think a lot of these questions go back to the same core issue, which is landlords pursuing eviction of tenants outside of any formal legal process. So pressuring tenants to move without issuing an N notice of any kind or issuing a different kind of N notice. And I'll start and then pass it to colleagues, I think, who might know the finer details of the BC case that you mentioned. In all those cases, I think our first priority is a tenant in that unit who understands their rights and understands that you do not need to move because a landlord tells you they're going to renovate the unit. You do not need to move when you are given an N13 notice, that a tenant has access to resources that can, they're sort of for lack of a better term, the first line of defense against that kind of landlord behavior. I'll also flag that like 48% of households in Toronto are renters. It's a lot of people, and information really is the best and clearest way to make sure that first line of defense is there and tenants understand what next steps they can and should take and understand their rights that exist whether or not a landlord tells them they need to move. I don't know, Aisha or Ted, if you want to add anything else about the specific case in BC or jurisdiction in BC, if you know of it.
Through the chair. Thank you for the question. It's a very good question. We have done research on other jurisdictions, including BC. We will note that some BC municipalities actually repealed some of their renoviction-style bylaws when the province stepped in to oversee rules and regulations for renovictions at a provincial level. And part of the reason that we are moving forward with the renovictions bylaw, as was stated in our original report, is the lack of provincial action on this. So we are hoping that in the future there is some progress in terms of having provincial actions taken on the issue of renovictions, similar to BC. What I will say as well is that we have, through our research, we've also seen that the Hamilton bylaw is a fairly robust model as well. We've been directed to model the implementation of this particular bylaw based on the Hamilton bylaw as well. And then lastly, what I'll say about informal evictions, because I think there's been a few very good questions about informal evictions as well, is that a really key part of this strategy is also going to be citywide public and stakeholder education to get to tenants before they're even evicted informally by their landlord. So while the actual license that is being applied for by a landlord may require an N13, we know, as the committee knows, that many tenants will get a phone call, an email, a lack of documentation when they're being evicted. We want to make sure that we have information in the hands of tenants at that point as well, in addition to building a robust bylaw for landlords that will apply and comply. So that's going to be a very key part of the implementation of this strategy, is that citywide public and stakeholder engagement focused on ensuring that tenants have the information on their rights to prevent evictions.
So, and I'll just conclude and say that as part of the bylaw, as part of the implementation, collecting information on these types of activities is going to be a key part of it. A measure of success of this bylaw would be a decrease in N13 notices. But has that led to an increase in N12s or other types of rent? That will be a key question. There has been a lot of discussion that is very much a possibility, that sort of shift could happen. But right now, it's very, very difficult. The data is limited on these things, even as far as the number of N13 notices being issued. The data is quite limited. We only know about the ones that have been appealed, which is a relatively small number. So getting a good handle on exactly what those numbers are will allow us to better enforce the bylaw, better inform the public. The city may be very limited. The city may be limited in what it could do about those other types of evictions, but if we were to provide information about those in tenants' rights, that would be a potential outcome of that monitoring. And again, another way to enforce those more difficult things to codify in a bylaw.
So seeing no further questions at this point, oh, sorry, Danielle.
Sorry, Elizabeth. I don't know much about the Hamilton bylaw, but it was only passed in the spring, I believe, right? And so our experience of understanding what's happening in the implementation is still pretty limited, like 5 to 6 months. So I'm just curious, thinking through, like, what are some of these loopholes that we've been chatting about that we might need to watch out for? What has been some of those that have happened in Hamilton? And then it was just alluded to some of the ways to track how it will play out here in Toronto, and some of the metrics that are going to be used to track, obviously, like the number of N13s, but then the other ways that landlords may find a way to conduct a renoviction. I'm curious, can you speak a bit more to, like, what are the metrics that we're going to, I heard a bit of an allusion, but more about the metrics that we're going to use here. And then the first part of the question was, like, how is Hamilton tracking it? What is their experience been in the 5 to 6 months that the bylaw's been in place?
Through the chair, I can take the first part, and it's actually even more difficult than that. Hamilton hasn't even implemented their bylaw. They'll do that in January 2025. So we are sort of following in their lead, but they have yet to actually bring it into force. So in terms of lessons learned from actually implementing it and dealing with specific cases, that knowledge isn't there yet. But I will say that there's Hamilton, as well as a number of other municipalities across Ontario, that are meeting regularly to look at dealing with this problem of renovictions, again, all sort of following Hamilton's lead. But through some of those conversations with other municipalities, we also start to discuss potential loopholes, gaps that need to be addressed. And I think part of the report that's coming to October will highlight some key areas in which we're, based on the consultations and based on some of the analysis we've done, are recommending some enhancements to what Hamilton put in place. But unfortunately, none of them will be able to speak to actual experience implementing the bylaw in Hamilton. And I think the framework around residential tenancies is a bit different in BC as well, although of course there are lessons to be learned there. One of the key areas that we are looking at and have talked about in the consultations, for example, is a public registry in Toronto. Hamilton does not have a public registry. We're considering a public registry so that all renoviction license applications would be public. And I think that's one area in which that sets up a framework for monitoring, where Hamilton does not currently have one in place. In terms of other things, I don't know, Ted, if you want to add anything in terms of the monitoring framework and other items we're looking at beyond what you referenced.
Not too much beyond what I referenced, but just as far as what we would be measuring, the most obvious would be the number of N13s appealed versus if there was an uptick in another type of eviction that started to take place, and we started to witness that shift. A lot of the data that we could collect would be determined through the implementation process. Yes, we will have a bylaw with certain requirements. Those requirements aren't necessarily there to collect data, they're there to regulate a process. Through the regulation of that process, through those applications, for instance, through the number of N13s versus N12s or whatever are issued, that's where the data would come in. And so through ongoing discussions with this committee, now that you've heard about it and once the bylaw's in place, if there are any thoughts that this group or that any other groups have, that certainly would be something. It may be something that we could add on an application form, maybe something that we could look out for through the enforcement or through the implementation process. We'd certainly be interested in hearing the type of data that this committee might be interested in.
Thank you. Are there any further questions from the committee before I wrap this up? So I want to say thank you to the staff. This was a very helpful presentation. Also, oh, is there a question? Joy.
It's a comment, actually, and that was a really good discussion. Thank you for the staff. I think it was very helpful. You were also noting that the city is considering whether an exemption for the renovictions bylaw should be provided for community housing providers. And I think the answer is yes, that you should exempt them, partly because there's no, the issue is fraudulent eviction or under, fraudulent terms. Nonprofits have nothing to, they can't make a profit on this, so they don't have that profit motive. They're mission driven typically. They won't intentionally evict someone into worse conditions. The costs, especially any sort of punitive costs, will effectively end up in, being paid for by the public. So I think this is the right direction. So just my 2 cents.
Thank you. And so thank you to the committee for asking lots of really great questions of clarification. I believe staff came to us in a request to consult on this and to get, we are a housing rights advisory. I don't think we got to the human rights, housing rights elements of this. And so my recommendation would be that we have a working group that is focused on maintaining housing. I think this fits squarely in that area. And so my suggestion would be that the staff, if they are wanting to hear more, that the Housing Rights Advisory Committee Working Group on Maintaining Housing look at this from the human rights lens. I think we've had a wonderful opportunity to get clarity on what is being brought forward. I think now the work is to provide some feedback in terms and offer advice in terms of the housing rights and human rights implications. And so I have a motion before me to move that request that the Maintaining Housing Working Group consult on the draft Renovictions bylaw to offer their recommendations and advice. If I could, that is moved, can I put that to a vote and see a show of hands? The timeline for this would be, because it would be in the next 2 weeks so that it gets back to you, to the staff, before they bring it to the Housing and Planning Committee. So it would be the first meeting of the working group. So can I see in favor? I'm seeing I'm seeing hands go up, and Harmony's up, we're all up. Okay, so thank you, carried, all in favor. Thank you very much to the staff. Really appreciate the very detailed work that's going into this. I'm going to suggest that we take a 7-minute break, maybe 10 minutes. Let's reconvene at 10 after 11, and that will take us to our next item on the Shelter Safety Action Plan. So let's take a break. We're going to get started. So is everybody back? 1 minute. All right. Nice to see everyone's faces on the screen. Hello, everybody. Okay, so we're going to get started. Back on script. We are now on item 3.5. Overview and discussion of Toronto's Shelter Safety Action Plan with a presentation from Toronto Shelter and Support Services. This is a presentation from Joseph Stalteri, Director of Service Planning and Integrity, Toronto Shelter and Support Services, outlining the approach and steps in the development of the Shelter Safety Action Plan. Over to you.
Thank you, Chair. Good morning, committee. Thanks for having us. I'm Joseph Stalteri. I'm the Director of Service Planning with Toronto Shelter and Support Services, and I'm joined by my colleague, Ashley Dalton, who is the Manager of Strategic Planning and Service Planning. So this morning we are going to talk with you about some of the work that we've been doing with respect to shelter safety in our system. In May, we came to the committee and shared with you very briefly about some of the work that had happened and had indicated that we would be coming back to committee to talk further about some of the work that we want to do in consultation with all of you. In April of this year, our General Manager of Toronto Shelter and Support Services, along with the lead researcher for the Centre for Addiction and Mental Health, had provided a presentation to the Economic and Community Development Committee on the work of the CAMH Shelter Safety Study. Through that committee, there was a recommendation to engage with and consult with the Housing Rights Advisory Committee. And so we're here today to talk with you more about some of the work that we've undertaken and the work that is ahead of us. So our objectives today is to provide the committee with an overview of our approach and the steps in the development of the action plan. We also want to share with you some of the work that we've done in engaging our partners and stakeholders in this process, as well to determine how best to engage members of this committee. So I'll give you a bit of a background and overview of the CAMH Shelter Safety Study. In 2021, Toronto Shelter and Support Services reached out to CAMH for some support in looking into the issue of safety in our shelter system. And we were looking to have more of a research and evidence-based review of the shelter system with respect to shelter safety. And our partners at CAMH were supportive of this, and this resulted in a 2-year study that went from 2022 to 2024, looking at the various factors that contribute to physical and psychological safety in the shelter system. In spring of this year, the final report was released with 22 recommendations to advance safety in the shelter system. And this is the report that I mentioned was provided to Economic and Community Development Committee. So there are a number of recommendations, 22 recommendations. I won't go through all of them here. This presentation is public, and the report itself is also public and easily found, and we can certainly help you with accessing that if you need. But to summarize just some of the key themes from the recommendations, mainly we're looking at doing some work to review and improve service restrictions, particularly around data management, processes and policies. And a number of the recommendations that you'll see speak to the work needed around service restrictions. Secondly, there was a number of recommendations that speak to the development of a specialized program to support people in the shelter system with extensive histories of violence and service restrictions. Thirdly, We're looking to increase access to mental health and crisis interventions for people in our shelters. And finally, improving and strengthening the training for our frontline shelter staff. So these 22 recommendations generally fall within those 4 broad themes, and that's really what we're looking to advance and do some work on. I will say as well that since prior to the shelter safety study undertaken by CAMH, and since that study, a number of actions have been taken by Toronto Shelter and Support Services to address safety in the shelter system. Particularly with respect to improving safety for staff, TSSS, that's Toronto Shelter and Support Services, has implemented a behavioral risk alert system. We call it BRASS, and the focus of BRASS is to increase workplace safety for all shelter providers. And the focus of the BRASS system is really about information sharing across the various shelter programs in the system. We've also, over the past 2 years, worked to implement initiatives to improve staff mental health and well-being. We've developed a divisional psychological and well-being strategy, as well as conducting and coordinating debriefing sessions for staff that are impacted after serious occurrences of a violent incident. We've also done some work to improve safety for clients. In 2023, Toronto Shelter and Support Services released an update to our Toronto Shelter Standards. Those standards provide guidance to the shelter system with minimum requirements for what shelter providers need to meet in the delivery of shelter services. And the update in 2023 was to introduce new mandatory standards for confronting anti-Black racism. And the focus on that was really to improve the experiences and remove barriers to services for those clients. As well, TSSS has continued to strengthen our harm reduction supports in our shelter system. We work closely with our partners at Toronto Public Health, as well as our community partners, Parkdale Queen West Community Health Centre, the neighborhood group, to strengthen some of the work that we're doing with respect to harm reduction to support people who use substances. This partnership, these initiatives and these partnerships have been very significant and have resulted in a decrease in the suspected non-fatal overdoses at shelter locations over the last year. As well, we've done some work to build sector capacity. The city's invested $14 million to date in our nonprofit shelter system for our providers to address the wage and benefit gap between community providers and city operations. And this work really can help providers focus on staff retention, training, service levels, and just general stabilization of those services. As well, we continue to do work with our sector partners and intergovernmental partners to facilitate access to health, mental health, harm reduction services across the homelessness system. We've also done some work with our Indigenous serving shelters to ensure that there are culturally appropriate mental health supports for Indigenous people who use shelter services. So with all this work undertaken to date, with the CAMH shelter safety study further informing our work, TSSS continues to be committed to prioritizing shelter safety. We continue to work to make improvements to the system for both our staff and service users. And we recognize throughout this work that it's important that we bring a housing rights-based approach to doing this work. And so this is also a priority for us as we develop this shelter safety action plan. So our approach following the CAMH shelter safety study, along with some of the initiatives that we'd begun to undertake, along with other actions that we've identified that needed to be taken, TSSS developed a plan to work through the implementation of the recommendations from the shelter safety study, along with some of the other actions that we've identified need to be taken in our system. The Shelter Safety Action Plan really is that key document for us that outlines those initiatives, those areas of focus that we want to prioritize to promote safety in the shelter system. And so to further inform the development of the action plan, we have begun engaging with a number of our stakeholders, and that includes our shelter providers through our Toronto Shelter Network. We've engaged people with lived experience and living experience residing in the Toronto shelter system. Recently, we held a roundtable with mental health service providers to further inform how to implement some of the recommendations from the study. We've engaged with city divisions who have and provide service to people with people who are experiencing homelessness, particularly around crisis intervention and harm reduction services. And a key stakeholder in that engagement is the Housing Rights Advisory Committee. So just a very brief overview of the timelines, where we've been and where we are going. The first part of the spring was really to plan and coordinate this work. We've reviewed and analyzed the recommendations related to safety, and outlining some of the key priorities and the scope of the work, and drafting a consultation plan. Beginning this summer, we've begun to engage with a number of the stakeholders, including people with lived and living experience. Many of our shelter providers were engaged, as well, as I mentioned earlier, with some of the health and mental health sector providers as well, just recently. The plan is to, again, engage with the Housing Rights Advisory Committee and further inform the development of the action plan and develop a roadmap for how we will implement the recommendations from the CAMH Shelter Safety Study. As directed by committee, we are reporting back to, and by committee I mean the Economic and Community Development Committee, we will be reporting back to ECDC in Q4 of this year. And so the fourth phase of our plan here is then moving into implementation and monitoring. And so we see that from December 2024 onward, which is really about the implementation of the actions that we identify through this Shelter Safety Action Plan, and monitor the implementation of that, our progress towards completing that work. So in terms of consultation with the Housing Rights Advisory Committee, we would like to, as I mentioned, consult with members of the committee to inform the actions and the roadmap for how we do this work. We have, some questions that we would like to engage the committee and probably one of the subcommittees and working groups that will be formed. Some of the questions we want to ask are, what are the actions, interventions that you would like to see prioritized as we work to enhance safety for both clients and staff? And also, in particular, what advice do you have for including a housing rights lens and approach to shelter safety as we develop the action plan? So those are some of the questions that we're looking for input on from the committee members or the working group that you may direct us to. So that's it for my presentation. Thank you very much, and open to any questions you have.
Thank you very much. Before we go to committee for questions, we do have a speaker on the line, so I'd like to turn it over to, I believe it's Emily McMillan. The floor is yours for 5 minutes. So where is Emily? Do we have her?
Hi, can you hear me?
Yes, we can.
Okay, perfect. Good morning, City Council. My name is Emily McMillan. I have decided to speak today as I have a need to ensure that the Council hears from a community member advocating for the rights of people who are unhoused, people who use drugs, marginalized individuals, and those who have been excluded as members of our community in the many letters written and signed by Niagara Neighbors for Community Safety. I am a registered nurse living in this city. I work with many individuals experiencing homelessness and have seen how current lack of resources affect one's ability to survive in this city. I have sat near a phone calling and recalling central intake hourly. It is extremely rare to be told that there is an available shelter bed. In my 2 years of living and working in Toronto, I have only once secured a shelter bed through central intake. Telling someone that there is no place for them is demoralizing. And this is a too known experience and should not be normalized as a statistic. Our community members deserve better. I know that shelters are not a fix-all solution, that there needs to be focus on upstream approaches of affordable food and housing, social supports, and access to mental health care, to name a few. I know that shelters are an emergency measure, and I know that we need more in this city because we are experiencing an emergency. The weather is about to get colder and people will freeze on our streets. We need to be prepared to provide secure safety beyond warming centers. Everyone in this city deserves a place to call home, whether that be a temporary home in the form of shelter or a tent. Everyone deserves safety. Everyone deserves housing. We cannot expect people to be their best selves while struggling to stay alive. At the end of the day, I have a home to return to. I have a bed to sleep in. For that reason alone, I need to use my privilege of being housed to advocate for those without housing, rather than filming, taking pictures, and shaming people in the streets who are likely in the lowest point of their lives. In order to have a safe community, everyone's safety needs have to be met. Thank you for your time.
Thank you, Emily. With that and with the presentation from staff from Toronto Shelter and Support Services, we have an opportunity for the committee to ask questions, make comments. I will foreshadow that this is something that will go to the working group, the committee working group. Okay, sorry. First, there's an opportunity for committee members to ask questions of the speaker. I apologize. Is that a question of the speaker, Harmy, or a question more generally?
It's a question more generally. Sorry about that.
No, it's okay. I framed it wrong. That was my fault. Do you have a question of the speaker, Bahar?
Thanks for your presentation. Can you speak a little bit, since this report was being developed in the past many months, and this CAMH report and its recommendations is not as new as it was when it was released. Have you looked at the changes to your report or recommendations based on the closure of some of the supervised consumption sites?
Thank you for the question, but just before we move on and before we lose the speaker, the person who deputed, are there any questions to the person who deputed? That's okay. Seeing none, let's start with you and then we'll go to Harmy. So sorry for the interruption.
Fairly current and recent report, and many of the findings from that report continue to be very relevant. With respect to any changes that you may be referring to, provincial changes with respect to safe consumption sites, that is work that we are continuing to do to better understand the potential impacts of those changes. Those changes right now are not yet legislated, but we continue to monitor what the province will be doing with respect to any changes around those types of services.
Over to Harmy.
Thank you, Madam Chair. Thank you for your presentation. I have comments and questions, and my hope is that I can be as clear, because I wanted to make it as clear and productive, I guess, in terms of both questions and comments. The first question I have, it's in regards the consultation. And I guess here's where the comment comes. Anecdotally, we know that women experiencing gender-based violence often are not able to access violence against women, specialized shelters funded by the province. They are full every night, and they turn into other shelters, homeless shelters. And we know, again, anecdotally, this happens every night. So what end up happening is that we have Toronto shelters supporting or providing shelter to these families. And it's a bit of an interesting complexity, because we know that in a perfect world, we wouldn't have gender-based violence, I guess service users or victims accessing homelessness shelters. But it happens, and it happens in the city, and it happens every night. And so the question is, and without any idea of getting into the jurisdictional conversation, is in terms of the consultation and recognizing that the city does serve and house victims of violence, was there any group consulted? I know you are starting your consultation, and it will probably run up until November, if I understand correctly. Has there been any attempt to include those groups to learn more about the realities of these families? And when I said the realities, I guess I'm thinking more specifically about safety. Their safety concerns are quite different from others. And so that's the first question. I have a couple, but I don't want to take too much room, so I'm going to leave it at that for now.
Through the chair, thank you for the question. We recognize some of the pressures that you've identified with respect to the violence against women shelters that are administered by the province. And we also recognize that there's a role to play for the city shelters, particularly when those violence against women shelters are full. The city has taken a number of steps to enhance the work that we're doing and ensure that there is safe space for victims of gender-based violence. We have women's only shelters. We have a 24-hour women's drop-in. Through our homelessness services capital infrastructure strategy, we've also identified the need for more appropriate shelters for women. To answer the question directly, we have and continue to engage with people in our shelter system who are victims of gender-based violence, and will continue to do so as we develop this plan and the work that we do in general.
Okay, Madam Chair, should I go to my second question, or maybe allow for other questions?
Go ahead.
Okay, thank you. I am very pleased to know that you are aligning this report and this work with a few other strategies that have been developed by the city, particularly SAFETIO, the Community Safety and Wellbeing Plan, and a few others. Could you provide some information as to what does that mean specifically when it comes to implementation? Can you help me understand how does that alignment works in like day-to-day kind of operations as you are aiming to implement this work?
Through the chair, thanks for the question. You're right, there are a number of initiatives that the Shelter Safety Action Plan align with. I referenced earlier the Homelessness Services Capital Infrastructure Strategy, which is a strategy that Toronto Shelter and Support Services has developed and was approved by Council in November of 2023. And there's a clear alignment there with this work. As I said, as we develop out long-term purpose-built shelters, consideration is for the unique needs of people who use the system, and in particular, the specific populations of people in our shelter system are key considerations as we build out a shelter system. And that includes things like the actual infrastructure, the safety needs in the system as well. So that's one example. We also work very closely with our partners in Toronto Public Health. Our Health, our city plan is a key initiative that informs the work that we do in Toronto Shelter and Support Services, including the development of our Shelter Safety Action Plan. And as we work to implement the action plan, we do that in alignment with many of the recommendations from Toronto Public Health's Our City plan. You also referenced Safe TO. Again, as we look to develop and implement the recommendations from the CAMH shelter study, some of those recommendations speak to strengthening and exploring a restorative justice model for people in our shelter system, and we will be doing that in consultation with our colleagues in social development, finance, and administration who lead the Safe TO work.
Thank you.
Thank you.
Looking to the committee if there are any further questions or comments at this time. Bahar.
I have a question for the clerk. There were a few different letters that were shared on this item by a neighborhood group. Just curious, do we ever see those letters? And I mean, I can imagine what it's about because they have a website, but just generally.
We did receive a number of letters, all stating similar, if not the same content. So our staff is still working through them. They came in probably over the weekend and overnight last night and into this morning. So we're still working on that. We have posted a document to our website that states the number of communications we have processed at this time, and it states the form letter that, maybe not the form letter, but the content of what the majority of the communications were stating. So that's available on our website for our members to view and for the public to see as well. But we're continuing to update that, and we'll probably continue to update it until we're done with the communications after this meeting.
Could we request that that be sent to a link to that be sent to the members? Thank you. Are there other questions of the committee at this time? B.
I think to deal with safety in shelter, I think two main maybe you can say factor area to look into. One is the staff, and then the second is the system. I find most of the staff, they don't have the skill to handle if something arises, some issue arises, right? They are very good in two things to deal with things. One is they threaten you that, you'll be kicked out. Second, they will call the police. So these are the two ways they always deal with if something arises. I think the staff need to have to handle the issue more skillful, not just like in threatening the client. You're not happy or whatever, leave. Or don't you're not happy, go. Or if you they will say you will be kicked out by threatening, or they will call the police. I think they need a training on how to handle things when something arises. And second thing is the system. I think, I don't know, TSS, probably you have your infrastructure, how the shelter should be run, right? But I think every shelter, I have been to the agency-run shelter and then the city-run shelter. The city-run shelter just drive me crazy. It's worse than the agency-run shelter. I find that a lot of rules they put out is not to protect client, but to protect the staff. For example, before we had the meal catered by the hotel, and then the food is like, from the package to us, so it's not good. So now they changed to outside caterer. The hotel one is bad. From the package, one time I got burger, not cooked. The wrapping is attached with the burger. Like if it's going to the oven, it's crispy, the wrapping paper, right? But it's wet. It's not cooked, right? And then sometimes they had this, I find this rubber band in the food. I say they didn't even wash the vegetable, and they just dump it in the soup to make the gravy. So they didn't even take out the rubber band. So I'm thinking they didn't even wash it, just dump the vegetable. So anything that is happening, and is like, for example, the food, right? I'll go to the staff. But it seems like nothing is done. They are very good. Like the agency, if you go something wrong, we go to the staff, they will deal with it, they will solve the problem. With the city staff, you go to them, they don't want to talk to you. They say, here is the form, complaint form, fill up the complaint form. I got so fed up about this nonsense. So I fill out the form. Until now, more than a year, I didn't get an answer about my complaint. So I kind of doubt that complaint didn't even send it, to whatever the party that need to be addressed. And then recently because we got new caterer, so they didn't have this coffee, right? So the shelter got a pot for the hot water and the cold water. So the hot pot, I don't know, maybe the staff didn't fill the pot, it get burned, only less than a month. And then they bought another pot, used, I don't know where they get that pot. It's leaking. It's not very good one. The first one is like it turn, and then you pour the water come down. The second one is you have to press it, that kind of pot. And because of that, and then because it's leaking, it's not a new one, it's an old one. I don't know where they get from somewhere. Because of leaking, they put the pot instead of near the edge, because when it's near the edge, the sprout, then you can, because most of the client have their own, what do you call that, bottled water. No, the flash, their own, what do you call that? Like what you have there. Yeah, those kind of things, right? I don't know what you call in English. So when they fill up, right? Instead of using the cup. When you put near the edge, then you can do it like without touching the sprout. But because of leaking, so they put away from the edge. So there's no way for them, because it's long, there's no way for them to get the water. So they had to put it in an angle, so all the water all touch the sprout. I mean, the opening is narrow, right? So they have to get it all to the top, to close to the top of the spout. I told the staff, this is not hygiene, nothing is done. And then so I have to drink, right? So I drink, but then after a while I get so sick. I got so sick, I get coughing. Every time I drink that, I get coughing, very bad coughing. So I decided not to get the water from there. So, but there's inside the kitchen, there is a tape, like the hot tape, or the kettle, the boil. We are not allowed to use that. Only the staff use those. So because I cannot drink the hot water from outside, so I asked, can I get the water from inside? They said, no, that's only for staff. They say, you use the outside one. I say, I cannot use the outside. Every time I drink the outside one, I get so coughing, I got so sick. I say, but when I use the inside one, nothing, no coughing. I say, I'm not going to do that anymore. I'm not going to get myself, and because of that, the staff don't want to give me, so I didn't have enough water. I had a hard time to pee, and it's painful. And then they said, they refused to do it. I say, I have to get the water. If you don't allow me, I'm going to ask the public health to come and inspect, because this is not hygiene. The frost, they drink from there and then they put it into the spout to the top. It's all the saliva, and then now COVID's increased, up again. I say, you don't want to get outbreak, and they say, why other people no problem? Why only you? I say, I don't know. Maybe my stomach is more sensitive. My body is more sensitive. That's why, like when I was in agency, run shelter, they don't have fridge. So I got my mail, because they say, if you don't take it now, you'll be gone. I'm going to shorten it, yeah. And then there's no fridge. So I got 1 whole year diarrhea because I'm eating those food putting out for long. So I'm saying that they don't care about the client. All the rule is to protect the staff. So I'm hoping this thing will change, because to me it's ridiculous. And there's more to talk about. Because of time, I'm going to stop here.
Thank you, B. Do you want to respond to any of that?
Yes. Thank you, through the chair. Thank you for sharing your experiences with us. There's a number of things that we do have in place to help ensure that our shelters are adhering to minimum standards. Sure, the first thing is to have Toronto Shelter standards in place, which we do, and that applies to the system as a whole, both our community-operated shelters as well as our city-operated shelters. We also have a quality assurance team that visits each of the shelters regularly throughout the year to assess compliance with the Toronto Shelter standards, and supports organizations to make the changes that they need to help them comply with the standards. As well, what we also conduct annually is a client satisfaction survey that is directly input from clients themselves who are users of our system, and those results are gathered and shared with our providers, again with an opportunity to enhance and strengthen the work that they're doing.
I did that survey. They do it yearly, maybe like December. But it's not a very good survey, because it's like fill in the blank, right? It's like check off. There's no space for a client to write, what is the concern, right? So let's say, even, most of the clients who fill out the form say, it's not totally bad, the food, sometimes it's okay, but there's no space to write, right? So it's just check out. But when you check out, it's not really the answer you want to put, right? So I think that can be improved, maybe give space for people to write. Yeah. And then I think I have a consultation, I think, I can't remember when, a few months ago. And they said they're going to write into a report and submit to the council. So I don't know whether that one is done or not.
Through the chair, thank you for the feedback. I will share your suggestions around the survey with the team that's responsible for leading that work. It's very helpful. Thank you.
Are there any other questions or comments from members of the committee to the staff regarding this presentation? Saroja?
I'm curious, thank you so much for the presentation. I'm curious about the piece about staff wellness, and I'm happy to see that the budgets, the city's looking into increasing the budget for wages for shelter workers, and I'm wondering if you could speak to the correlation between, and whether there is a correlation or this was looked into for the research that you did around staff wellness and safety within the shelter systems, levels of safety within the shelter system.
Through the chair, thank you for the question. I can't speak to an evidence base for a direct correlation. I think anecdotally we can say that our staff also experience the effects of not just workplace violence, but just the overall pressures in the shelter system with a homelessness crisis, and the system being at capacity each and every night also has an impact on staff and their wellness. And so that has driven a lot of the investments that we've made to staff psychological wellness and well-being.
Thank you. I'm looking one last time to see if there's any questions. Anne-Marie.
Thank you, Elizabeth. Hello, everyone. I just really want to go back to acknowledge Emily for deputing. I think she did an amazing job in putting out her care or concern for the people in our city who are experiencing homelessness. And I think it's important that we acknowledge that. I also want to acknowledge Lindsay in the comment section for what she has shared also. That comment was well appreciated. Thank you.
Thank you. If there are no further comments or questions, and I'll just pause to make sure that there aren't, then I would echo Anne-Marie's comment. Thank you to Emily. I think it's important that we hear from members of the community and people speaking up for protecting the rights of those who are most vulnerable, and those are the people who are unhoused and also unsheltered. This is a really critical piece for our committee, ensuring that there's a shelter safety plan in place, that some of the issues raised by B in terms of feeling safe, feeling that there's an opportunity to raise complaints and see accountability within the system. All of this is about creating a system that we have confidence is doing what it can to realize the housing rights of individuals, some of the most vulnerable individuals in our city. My suggestion, as with the previous presentation from staff, is that we refer this and the work on planning to the working group on unhoused persons, or unhoused working group rather. And I would also ask if it's possible that when we have that consultation, which I think will be in fairly short order, again, because you will be reporting back to ECDC sometime in October?
November.
In November. Okay, so we'll probably try to make that meeting happen sooner, as soon as possible in October. If there's anything further around where the action plan development is, this is a helpful outline of where it's come from and some of the parameters of it. But if there's any sort of more detail that's available that could be shared, and then we can begin to bring a human rights lens to some of our comments and questions and sort of apply that framework, that would be really helpful. And so to that end, I would put forward a motion that we request that the supporting people who are unhoused working groups consult on the Shelter Safety Action Plan. So all in favor, if I could see a show of hands. Thank you. Carried. And that ends that. Thank you very much to the staff. This is important work, and we appreciate the time you took to come and brief us on where you're at. Thank you. I'd like now to return to item 3, which was regarding the request or the suggestion to have a formalized way of this committee connecting with the Ombudsman's office. Given the fact that the Ombudsman's office is part of the accountability offices of the city, it's actually not possible to have a written formality to that. But what we can have and I think the goal is that we have regular communication so that we are working in tandem to advance the right to housing, that we have a standing invitation to the Ombuds office to come to our meetings so that we can have an open flow of communication between the two. And so to that end, is there a motion that we can share with the committee? That we request updates on the housing unit's housing rights framework at each Housing Rights Advisory Committee meeting in 2025. So if that motion can stand, and if we can take a vote on that, that would be helpful. All in favor, if you could raise your hand. And carries with everyone in favor. So that concludes. We have one last item, and this is a motion to excuse absentees, although I think everybody is here today, so we don't need this. So what I would say instead is thank you to the committee members for coming out and for participating in the fullness of this meeting. This is important work, and I'm excited because after meeting number 3, we seem to be fully engaged in the work of the committee with lots of business to be developed and dealt with in the coming months. Our next committee meeting will be in November, and in between there you will be tapped for working group meetings so that we can continue to build out the agenda of this committee. So that concludes today. Thank you for everybody here. I will see you on November the 4th. Have a great day.